Hello everyone, and thank you for watching my presentation. My name is Terence Bong, and it is an honor to speak before the Parliamentary Working Group on Land Reform. Today, I'm going to discuss about whether the legal framework for land ownership and registration in England and Wales is truly fit for purpose in 21st century. We will talk about three topics today. First is the three fundamental principles underlying the system of registered land. Second is the mirror principle in practice. Third is a reform on Land Registration Act 2002. Before we dive in, I will briefly explain what is registered and unregistered land. Registered land is a land where the title, ownership, and certain rights, such as legal and equitable rights, are officially recorded at the land registry. It was governed by the Land Registration Act 2002. In contrast, the unregistered land is a land where the ownership title did not register at a land registry. It was governed by the Law of Property Act 1925 and the Land Charges Act 1975. Instead, the title of unregistered land is proven by the historical title deeds and the long possession in the land. There about 90% of the land is registered, but there are about 10% of the land did not register in England and Wales. After the introduction of the registered and unregistered land, now I'm going to talk about the three fundamental principles underlying the system of registered land. The first of these is the mirror principle. But how does it work? Imagine standing in front of a mirror. The mirror reflects your whole body and your whole face. In the same way that the land registry should work like a mirror to reflect everything about a piece of land, for instance, who owns the land, what right exists over the land, and others. Or we can say that what you see, what you get. The purchaser no need to go deep and investigate of the register title. The purchaser should be able to simply look to the land registry itself to find the information that the purchaser needs. In the end, the mirror principle is supposed to essentially allow the land registry to accurately reflect the reality of the property. In conjunction with the mirror principle, the second principle is a curtain principle. This principle means that the purchaser of land does not need to be concerned with the interest that exists behind the register, such as the beneficiary interest and a certain equitable interest under a trust. The purpose of this in principle is to protect a certain piece of confidential information and simplifying the conveyancing process. A purchaser of a land can just deal with the legal owner directly without investigate or engage with any hidden beneficiaries. This is because those hidden interests can be easily to be overreached. But what is overreach? Overreach allows a purchaser to take ownership of the land free from any hidden beneficiary interests, and those interests are not longer attached to the land, but instead move to the money paid by the purchaser. The beneficiary can claim their share from the purchase money, not from the land again. However, the purchaser must be aware that the overreaching process may require to ensure that they are fully protected and not bound by disclosed right. The doctrine of overreaching was outlined in Section 2 of the Law Property Act 1925, where land is sold by two or more trustee or a trust corporation. The beneficiary interest is transferred from the land to the purchase money. This protects purchaser from hidden interest by ensuring beneficiary receive their entitlement. Finally, the insurance principle. This principle means that the interests and rights of people are relying on the register that is protected by the state. When there is some mistake in the land register that cause someone to suffer loss, for instance, a purchaser buys the land based on the incorrect information given by the land registry, this principle will come into practice and require the state to properly compensate the loss that was suffered. This principle ensures that the public can trust and rely on the land registry for information and emphasize that the state had a duty to take good care to ensure that the information is good and accurate. The rule of this principle is stated under the Schedule 8 of the Land Registration Act 2002. A good example of how the insurance principle work can be seen in the case of Swift First Limited and the World's Chef Land Registry. In this case, the mortgage was registered under a forged document which was later removed by the register when the fraud was discovered. The claimant lost their right but still received compensation because the court held that the claimant relied on the register in a good faith. After introducing the three fundamental principles underlying the system of registered land, now I'm going to focus the mirror principle. Let's look at some of the key strengths of the mirror principle. First, it offers reliability for purchaser. The mirror principle means that the land register should reflect all the key facts about the land, who owns it, what right exists, and any limitation. This allows buyers to trust the register without needing to investigate behind it, making the conveyancing process quicker and safer. Second, under Section 27 of the Land Registration Act 2002, many key dispositions must be registered to take legal effect, like transfer, lease over 7 years, and legal charges. This ensures that what appears on the register is accurate and up to date. If it was not registered, then there are no legal effect. The third, the mirror principle supports legal certainty. Under Section 58 of the Land Registration Act 2002, when someone is registered as a proprietor, they are legally treated as a true owner even if there was a defect in how they acquired the title. This gives the system strength and confidence as you can rely on what you see. Although the mirror principle is meant to reflect all the essential information about the property or the land register, it does not work properly in practice, or I might say there is a crack in the mirror. One of the main issues of the mirror principle is the problem of overriding interest. Overriding interest means that a third-party interest which will bound the purchaser of registered title without knowing about the interest and showing up in the land register. Schedule 3 of the Land Registration Act 2002 listed the category of overriding interest. One of the important examples is the right of someone in actual occupation which stated in the paragraph 2 of the Schedule 3 of the Land Registration Act 2002. But what exactly is actual occupation? Interestingly, there is no definition under the Land Registration Act 2002, but the court have chosen to adopt more flexible case-by-case approach rather than providing strict definition. For example, a legal owner named Aman, but his mother lived in the house for 20 years. The court may recognize that she has an overriding interest through actual occupation, even though her name was not on the register. For an overriding interest to bind the purchaser, three main elements needed to be specified, including the person has a proprietary interest in the land, actual occupation of the land, and a reasonable expectation of the land at the time of the deposition, or the purchaser knew that the client had an interest. So, what is the problem of the overriding interest? The problem is it will cause uncertainty because the purchaser cannot fully rely on the register and must take extra steps to investigate the property before purchasing, which reducing the reliability and efficiency of the mirror principle that's supposed to provide. In addition, the Law Commission recognized that the overriding interests are a double-edged sword, where they undermine the mirror principle by allowing those overriding interests buying the purchaser. It also protects the vulnerable individuals that are in actual occupation but are not registered in the land registry. There are two cases which highlighted the limitation and exception to the mirror principle. The first case is the William and Glenn Bank and Boland, which the wife had an overriding interest that bound the bank when the husband defaulted on the mortgage because the wife had contributed to the purchase and being in actual occupation. The House of Lords held that the mirror principle does not apply to overriding interest. The other case is the case of Fairhurst Limited and Wallside Limited. The court allowed an overriding interest over the land although the person was only using one part of the land. This has caused the purchaser harder to identify what rights they are bound when buying the land. There are also other types of overriding interest such as legal lease and certain easements which are often more predictable and easily to be identified through inspection and inquiry compared to the actual occupation. According to paragraph 1, Schedule 3 of the Land Registration Act 2002, legal lease does not exist 7 years constitute an overriding interest. In addition, certain legal easements such as right of way may also be overriding interest under paragraph 3, Schedule 3 of the Land Registration Act 2002. The easements will bind the purchaser if the purchaser knew about it or it was obvious upon a reasonable inspection. If neither of above applied, it was used within 1 year before the sales, can also be constituted an overriding interest. Another issue is that 10% of the land in England and Wales are unregistered. The mirror principle cannot operate in those cases because there is no register to reflect ownership or interest, must rely on old title deeds and paper records which are harder to access and identify and more likely to cause dispute and delay. After listing the limitation of mirror principle, now I'm going to talk about the reform on Land Registration Act 2002 and a conclusion. The first reform is fixed gap in the insurance principle. Under the Schedule 8 of the Land Registration Act 2002, a person only can claim insurance if their loss was caused by a mistake on the register that has been or could be rectified. This means that if there was no mistake, there are no compensation will be awarded. For example, in the case of broken banks and guys, in this case, a mortgage was added to a person's lands by a fraudster, which later got the land back, but the mortgage was still stay on it. The court said that the mortgage registration was not a mistake, so the owner will not get back the compensation, and last the owners on the land with a huge debt. The Land Registration Act 2002 should be reformed to allow for any losses caused by an early mistake, even if the current register does not show an obvious error. The second reform is requiring compensation land registration and fully introduce e-conveyancing. Currently, around 10% of the land in England and Wales are still unregistered, which cause the land register hardly to reflect the ownership or interest of the land. In that sense, this has weakened the mirror principle because there are no register to rely on for unregistered land. Compulsory land registration will ensure that all the land in England and Wales has a clear and centralized record to enforce the legal certainty and reducing reliance on old title deeds. In addition, Land Registration Act 2002 had introduced mandatory electronic conveyancing under the Section 93 of the Land Registration Act 2002, but this conveyancing was limited when exchange and completion occur only. This means that e-conveyancing that had not fully developed. To overcome this limitation, the Law Commission proposed a new Section 92A of the Land Registration Act 2002, which enabled more flexible implementation, which allowing all part of conveyancing transaction to be made mandatory electronically. The third reform is reduce the scope of overriding interest. Since overriding interests are rightly regarded as a double-edged sword, it cannot be eliminated fully. Because the overriding interests uphold the justice of vulnerable individuals which may lack of legal knowledge or means to register their interests. However, this interest also undermine the certainty of the register. To balance the fairness and the transparency, reform of overriding interest is necessary. For example, narrowing the scope of overriding interest by excluding the certain easement or limiting the protection of actual protection to certain circumstances. The last reform is the public legal education. Public legal education is an important reform to support the effectiveness of land registration. Individuals must be educated about their rights in land to ensure that they are aware of those rights. If those individuals did not know about what rights they have in the land and how they should be protected, unregistered land will remain exist in England and Wales and restrict the development of e-conveyancing. In the end, although the mirror principle is a fundamental part of registered land regime offering legal certainty and efficiency, the curtain and insurance principle are equally essential to its overall operation. However, in practice, the mirror principle is limited by the existing of overriding interest and the continued presence of unregistered land. Therefore, reform is necessary to ensure that all three principles can operate effectively and fulfill their intended purpose. Thank you for watching my presentation, and I will see you in the future. Goodbye.